All right, ladies and gentlemen, I'm going to call the Karnes County docket on the civil side. I'm going to ask for announcements from attorneys. Anyone who's present who does not have an attorney or whose attorney doesn't answer, please let me know you're here. Apart from, make sure your electronic device is muted. In the interest of ML Garza, a child.
That case is dropped, Judge. We received a call yesterday from Vestal's office.
I'm sorry. Tax case, Karn City ISD versus Leslie Clemens.
Good morning, Your Honor. Jeff Garcia on behalf of the plaintiff, Karn City ISD. And we're ready on this. However, I believe Ms. Jennifer Dapia has been appointed ad litem on the case. I'm reaching out to her to see if she's going to be available this morning.
Intervener's ready, Your Honor. John Banks on behalf of the county.
She did call this morning, Judge. Let me make sure she got the Zoom invite.
All right, and it has, here she's coming, it has Stephen Barrera on here.
That's correct, Your Honor. There's been kind of originally Stephen was the ad litem on it, and then he approached the court. It's been about a good while now, and he got off of the case not wanting to do the ad litem work. And then I believe Mr. Cedillos at one point was appointed ad litem on it, and of course, Mr. Cedillos was not on it. And now we're with Jennifer Dapia at this moment.
I'm present, Your Honor.
Okay, and are you ready to go on the Karn City versus ISD versus Clemens? Do you need to confer?
I'll confer with Mr. Garcia. I just obtained a copy of the will yesterday and was able to figure out who was in charge of what and everything. And so I've reached out to them, but I haven't heard anything back yet. So, but I'll confer with Mr. Garcia.
All right, I will I've just made Miss Riley the host. I'll ask her to work on breakout rooms. In the interest of Ryan Noel Briand, a child.
I'm present on that, Your Honor. That's our motion to modify the child support obligation. And I don't see my client on here. I'll have to get in contact with him.
All right, and Ms. Barrera?
I believe Ms. Bryant is representing herself, Your Honor.
Yes, Judge, I'm here today.
Okay. And would it be helpful to confer?
I'll confer with Ms. Bryant, Your Honor.
Karn City ISD versus Jacqueline Wishart.
Your Honor, we're plaintiffs are ready on that case.
Intervener's ready, Your Honor.
The estate of Elizabeth Moss, deceased.
Your Honor, Joe Jackson here on behalf of Kathleen Moss, as independent executor. I believe we've set this morning just a hearing to approve the inventory, and I would think that that would take less than 10 minutes, but there are, I guess, objections to it, and apparently Mr. Moss has filed a removal action. We might need some more time to deal with that. I don't know what kind of time announcement Mike Finkel wants to make for that.
Your Honor, I'm present on behalf of John Moss Jr. I think we announced an hour when we said it. I think that'd be plenty of time. The issues, as counsel said, is the inventory. And then we have also filed a motion to remove and substitute the executor.
And Your Honor,
okay.
I
heard removal action, and I was wondering how an estate was going to get removed to federal court. And thank you.
Sorry, Your Honor. On the application to remove the executor, I don't believe that's properly on the non-jury docket. We had requested a jury trial for that, and had filed that answer and paid the jury fee. So I don't know that we can hear that matter this morning, because it should be set for a jury trial sometime in the future.
Okay, I'll mark you conferring and ask you to confer, and any documents or pleadings I need to look at, if someone would post those to me in chat, I'd appreciate it.
Okay.
Christian Aguirre, a child.
We're present, Your Honor. I'd like to confer with Mr. Flores, if I may.
I believe I saw him log on.
He is on there. I think he just.
Yes,
got-
Your Honor. Hi, good morning, Your Honor. Yes, that'll be fine. We'd like to confer.
Okay.
Can you hear me, Your Honor?
Yes, I'll ask you to get with court coordinator, Ms. Riley, at that office.
There's a Spanish interpreter on that case as well, Judge.
Yes.
Hector
here,
Ramos is
Judge.
here.
And you're the host right now. If you will get the interpretation turned on.
Okay.
Mr. Ramos, would you raise your right hand? Do you swear or affirm that you will, to the best of your ability, translate between the English and Spanish languages the statements of the court, the attorneys, and the witnesses, so help you God?
I do, Your Honor.
And are you a certified interpreter between the English and Spanish languages in this state?
Yes, sir.
All right, thank you, sir. Cnty Corporation versus One Way Services LP.
Good morning, Your Honor. Matina Tumanides here for the plaintiff movement. This is a no answer motion for default judgment. I don't anticipate an appearance by the defendant, so I'll need 5 minutes maybe.
Okay, give me just a moment. Okay, I'll mark you as number one. In the interest of Mila Rose Cano, a child.
Andres Dios here on behalf of my client, Adam Cano, Your Honor.
And is the other side present?
I don't see her. I'll just need a breakout room, probably about 10 minutes. It's temporary orders, Your Honor. I need a breakout room so I can talk to my client.
All right, if you'll get with Ms. Tell you about that. All right, add-ons, state of Texas versus $1,896 in US currency.
William Richmond for the state. This is a motion for default judgment. It should take about 5 minutes.
I'll mark you number two. Was anyone else told to be here today? No? All right, I am going to get into the district clerk's files for Karnes County. And let me look at the Cnty Corporation. I'll pull that case up and then we'll pull up the state's case. Everyone else is excused to confer.
Mr. Diaz, you need a breakout room with Adam Cano, is that correct? Shit, I didn't hear you. You're muted. Is that correct?
Yes.
Okay, I'm gonna put you on breakout room 1. And Mr. Cano, if you'll accept that, you'll get a little pop-up window. Ms. Tapia, you needed a breakout room with Lorena Bryan, is that correct?
Yes, please.
If you'll go into breakout room 2. Does Chris Bryan need to go in there as well?
No, not at this moment.
Okay. Ms. Rojas and Renee Flores, do y'all need a breakout room just yourselves or anybody else in there? I don't know where they went. I'm gonna put you on breakout room 3. Renee Flores and Naida Rojas. If anybody else needs a breakout room, please let me know.
Hello? Hello?
Mr. Flores, yes.
Hello?
Yes.
Mr. Flores, I put you in breakout room 2. Do you have 2 devices? Because I have a Renee C. Flores in there in breakout room 3. Or do you have 2 open devices or what?
I'm not in the breakout.
And there's 2 Renee C. Flores is signed in. I'll put you in breakout room 3. I'm not sure if the other person's the right one.
All right, Ms. Tamanadid, go ahead.
All right, now I'm unmuted. Good morning. This is Plaintiff Centos Corporation's motion for default judgment. Defendant One Way Services LP was served through the Texas Secretary of State on October 20th, 2020. That citation is on file with the court and has been for the required number of days. I've calculated different.
When was that filed?
The Secretary of State certificate, that was
Yes.
filed, let me tell you exactly, on January 21st, 2021.
Okay. Okay, you can see that there's all right, I found it. There's a whole bunch of documents on the clerk's index that the only description is no fee document.
Okay.
But I found it. All right.
Okay.
Go ahead.
All right. So defendant's answer date was November 16th, 2020. And as of today, there's still no answer on file for the defendant. Plaintiff's claim is liquidated and proven true by the exhibits attached to the motion for default judgment. So plaintiff asked this court to enter judgment against the defendant in the following amounts: $43,579.38 in liquidated damages, $4,518.84 damages for unpaid invoices, $16,575 for damaged or unreturned items, $1,940.22 in prejudgment interest, post-judgment interest at the rate of 5%, and attorney's fees in the amount of $2,500. I'm happy to go into any detail that you need in terms of the pleading and the exhibits.
Okay, my only question is, I have seen before on occasion where Cntys's contract says that they can either, obviously you owe for unpaid invoices, but that they can either get X amount for all of the merchandise because they had to put people's names on it and stuff, or they can sue for 80% or 100% or whatever it is of the unpaid rental fees, but not both. And are you trying to collect both, or is that 16,000 stuff that that just wasn't returned?
That 16,000 is for items that were not returned. This contract involved specialty items. And I can show you exactly where in the contract.
That's fine. It's been a while, but I've seen a situation where Cntys said, if you return the stuff, and there was a contract, maybe they don't do that anymore, where it limited the amount of that Cntys could get on the unpaid, on the future billings if you returned everything, and they had, and I wouldn't let them do that. All right, then. Anything else?
That's all, Your Honor.
Okay, and let me download this, and I will sign the judgment and post it to the clerk's office in chat. And if you will hold on, I can get you an file stamped copy if you want one.
Sure.
All right, there you go. You're excused.
Thank you, Your Honor. Have a good day.
Okay, 2010-195. I'm going to pull up your case, Mr. Richmond.
Yes, sir.
All right, go ahead, sir.
All right, Your Honor. First off, I'd ask the court to take judicial notice of the court's file.
Okay, I will without objection.
All right, Your Honor, this is a asset forfeiture case. The particulars of the seizure are described in State's Exhibit A. This cause number was filed on October 26, 2020. The respondent, Stephen Ray Pacina, was served by certified mail restricted delivery on January 30th, 2021. The citation and proof of service have been on file with the clerk for at least 10 days, excluding the day of filing and today. The respondent has failed to answer the state's petition. State's Exhibit B is a certificate of the last known address of the respondent. State C is a non-military affidavit stating that to the after doing its due diligence, the state has been unable to see whether it has made the determination that the respondent was not a member of the United States Armed Forces on the date of the filing of the date this lawsuit was filed, nor was he a member of the Armed Forces on the day that this motion was served. So at this time, Your Honor, the state would move for Exhibits A, B, and C into evidence.
All right, without objection, their state's exhibits are admitted into evidence. Do you have a proposed order?
Yes, Your Honor, I am filing it right now. So
uploading in chat.
Okay, I can do that. All right, it should be there, Your Honor.
Yes. Okay, and I just posted that to everyone too.
All right, thank you, Your Honor.
Have a good day.
All right. Oh, Judge, since I have you right now, there are a couple post-conviction writs of habeas corpus. There's some housekeeping matters that I wanted to talk with you about. It would take about 5 minutes, but I understand you're in court right now, so if you'd rather me do that some other time.
Yes, let's do that later this morning, or later today. We'll see how the family cases go. I may be finished quickly. I may be here, but yes, let's get that done.
Okay. All right.
Here on the page.
All right. Thank you, Judge.
All right, and on the tax cases, are everyone ready to go on the Clemens?
Your Honor, I'm still waiting to speak with Ms. Tapia, confer with her on the Clemens case. But I believe we are ready on the second case, the Jacqueline Wisher.
Interveners ready, Your Honor.
Okay, let me see if I can pull that up. It does, okay. Okay, it looks like there was a pro se answer on the 26th of September 2019.
I show September 19th of 2019, the date of the pro se. It probably was received on the 26th, but that's correct, Your Honor. And we sent a notice of hearing on, but via certified mail on February 3rd, 2021. And that was delivered on February 11th, 2021. And it was signed for.
All right, go ahead, sir.
This time we ask the court take judicial notice of all documents, citations in the court's file. As the court previously noted that the sole defendant in this case, Ms. Jacqueline Ann Wisher, was personally served in Antonio at her home address and has answered in this case. The this property sent a notice of hearing to today's court setting and not appear at today's court setting. At this time, plaintiffs would like to offer.
And without objection, I'll take
No
judicial.
objection, Your Honor.
Prayed for.
Thank you, Your Honor. I apologize.
And let me ask you to slow down a bit, Mr. Garcia. I don't know about the Ms. Cavazos, but I'm getting some feedback or vibration or something in your speech.
I'm sorry, it's today's, I have bad internet reception today for some reason.
Go ahead.
At this time, I'd like to offer into evidence which has previously been marked as plaintiff's exhibits A, which are certified tax statements from Karn City ISD showing all taxes, penalties, and interest owing to plaintiffs.
No objection, Your Honor.
Without objection, the exhibits are all admitted into evidence.
Your Honor, interveners would offer what will be filing as soon as the judgment is, if the judgment is entered, the interveners exhibit A, which are the statements reflecting the amounts owing to the county.
No objection, Your Honor.
Without objection, they're admitted also.
Lastly, Your Honor, based off of those exhibits, plaintiffs and intervener join in asking for a judgment in favor of plaintiffs and intervener.
We join in the request. And Your Honor, I'd just like to add for the record that the husband of Jacqueline Ann Wishart, I have been communicating with. His mineral interest, I think, on these very same wells are going to be sold at an April 6th tax sale. And I have communicated regularly or repeatedly. He's not made any effort to pay, but he's aware of it. And I asked him, I let him know that judgment was being taken today, and I have had no response. So just to add to the fact that they absolutely know about the hearing today and aware of the consequence.
All right, thank you, sir. And do you have your proposed judgments?
Yes, Your Honor, we are getting amounts from our client who was out on spring break last week. They're catching up. We should have that judgment from all parties signed and all the exhibits e-filed, Your Honor.
Okay, I will look at them when they're e-filed and grant judgment for both parties, both plaintiff and intervener, in the amounts shown on the tax certificates.
Thank you, Your Honor.
Plus court cost. All right, you're welcome. Okay, do we have anything ready to go?
Judge, I'll submit an order. CPS was involved in this case. They took the child away from her. And we're gonna submit an order with some kind of supervised visitation and at least 48 hours notice to my client. I'll prepare an order and submit it to the court
Okay, that's on Kano.
on Kano.
All right, go ahead, sir.
Okay, I mean, you want me to put on some evidence or?
No, that's fine. Just
Okay,
e-file, or if I'm still online, submit that in chat.
okay, all right, Your Honor. Okay. that
Well,
doesn't
actually,
do it.
hold on. Somebody's checking in. Let's see who that is. I'm just about to make up a rule that says no defaults before 10 a.m. because it seems half of them that I take in that time get set aside because the person wanders in. All right, let me ask the district clerk's office, who is connecting on a cell phone there in the clerk's office?
Judge Wilson,
Yes, ma'am.
the gentleman trying to log in is in the wrong Zoom, so he needs to be in Judge Ellison, so he's about to log out. He's
Oh, excellent. Okay, sounds good. All right, then, Mr. Cedillos, yes. Mr. Kano, you are excused.
Thank you, Your Honor.
Your Honor, can you hear me?
Yes.
Okay, I'm working out the audio here, so I want to make sure I came back with audio. Yeah, Mr. Finkel and I have been conferring on the Moss matter, and I didn't know if you were ready to hear us or not. I'm still getting used to the Zoom presiding here.
Give me just a moment. I'm looking at documents on that
Yes, sir.
matter. All right, I'm back. Where do we stand on the Moss case?
Your Honor, Mr. Finkel and I have been conferring on this matter. You know, on behalf of the estate, we'd like to go forward with the hearing on the inventory, but it looks like on the removal action, I think we have a disagreement as to whether or not my client is entitled to a jury trial on the fact issues, you know, regarding the allegation that she should be removed. Yeah, I'm in favor of going forward with the hearing to approve the inventory today and hearing the removal action, or at least the challenge to the demand for a jury trial and removal action here in the next few weeks. Yeah, we've just been kind of visiting about that. Mr. Finkel, I don't know if you want, how you want to present that to the court on your side.
Right, Your Honor. In looking at the jury demand and preparing, I don't know that he's entitled to a jury on the issue of removal, but would be on the issue of the validity of the will itself. And so
I haven't seen anything where there's was a challenge to the will filed.
Correct. And so that's why I feel like the jury demand is improper. But I agreed to go ahead and file a motion to strike the jury demand as opposed to just trying to move forward on our application. I can get the jury, I'm sorry, the motion to strike the jury demand. And we can have that heard. We've consulted with Ms. Riley and March 30th is available. But I'd like to hear everything all at once because otherwise it's going to be duplicative. It's going to be a lot of the same testimony and information.
Your Honor, I don't know how any of the testimony or facts regarding approving the inventory are going to be relevant to his application for removal. And I say his, John Moss's application to remove my client and substitute himself in as executor. Yeah, I mean, frankly, getting the inventory approved is kind of holding up the estate on making distributions and getting a lot of that kind of stuff in progress for the estate and for all the beneficiaries, frankly. So we would prefer to move forward with that today, and we're ready to move forward with that today, but not his motion to strike our jury demand. And our jury demand has been on file for close to a year, Your Honor, on the issue of the removal action.
Okay. All right, now we're going to proceed with the motion to approve the inventory this morning. So go ahead, Mr. Jackson.
Hi, good morning, Your Honor. Joe Jackson on behalf of the independent executor, Kathleen Moss. We had previously submitted to the court an inventory appraisement and list of claims that is dated August 4th, 2020. I believe we've also previously submitted an order approving the inventory. And, you know, with all that's gone on in the world, here we are now, you know, in April or in March trying to get it approved, right? And in the process, there have been no formal objections to the inventory filed of record that I'm aware of. But I will let the court know, and I tried to submit, and I hope I did it properly through the chat function, some correspondence between Mr. Finkel.
Yeah, I'm sorry, Mr. Jackson. I need to speak with the clerk's office.
Go ahead.
All right, ladies and gentlemen, I need to step away from the bench for a few minutes. We will come back at 10:15 and we will get started at that time.
All right. Thank you, Your Honor.
Okay, ready to get going?
Yes, Your Honor. Oh, let me turn on my camera.
All right. Mr. Jackson, Mr. Finkel, I've finished up earlier than I thought I might have with my interruption, and I've been looking at the estates code. And 309.103 of the estates code, correction of inventory appraisement or list of claims. That looks to me to be the method by which an interested person can object to the filed inventory and list of claims.
That's 303 what?
309.103.
I'm pulling that up right now, Your Honor. I have it pulled up, Your Honor.
So I know there's a letter from Mr. Finkel, but is there is that it? I don't think that letter would constitute unless the parties agree to deem it as such, I don't think that would constitute a complaint under 309.103.
Your Honor, on behalf of Kathleen Moss as the NP executor, we don't agree to consider that a written complaint. And yeah, I looked to subsection A1. It says, to file a written complaint, and nothing's been filed with the court that we're aware of.
Okay, so my point is, I'd said we're going to go ahead this morning, but I don't know if there's a justification for having a hearing this morning. If at the conclusion of it, Mr. Finkel just files a complaint under 309.103 and sets that for hearing in the near future, we'd have to do it all the way over. We have to do it over. So on second thought, I think the better practice would be for Mr. Finkel to file his 309.103 complaint. That way, I'll tell Mr. Finkel that I'm going to assume anything that's not complained about is not objected to, at least in the absence of discovery of new evidence. That way, Mr. Jackson and his firm will know what exactly it is that's being contested.
Thank you, Your Honor. I would request.
That way we don't have to do this twice.
I would request leave of court to be able to do that.
I don't know that you need leave of court. It looks to me like you can do it after it's been approved.
Right.
Your Honor, typically when I've seen these, the inventory gets approved and someone comes in and file the objection. Of course, the executor, you always have a right to amend the inventory if there's subsequently discovered facts, and that's kind of typical in these kind of matters. And in fact, we had a colleague of mine at the firm, Sasha Kiger, had written a letter back to Mr. Finkel asking for additional information for some of the issues raised in his letter, and we have not received a response on that. Which is kind of why we're going forward with the inventory as is. The real property had been appraised. For some of the other matters pointed out in Mr. Finkel's letter, we had asked for additional information for those valuations, and we had not received that. So that's kind of why we wanted to go forward with the inventory as is, Your Honor.
Okay, I understand, but I'm not going to tell Mr. Finkel that this is basically an ex parte proceeding and he can't ask any questions or produce any evidence.
Sure.
But then that wouldn't preclude him from doing it twice. So I understand lots of times the inventory gets, I assume, signed off on without anybody. Then it just goes to the judge and the judge looks at it. I'm not a probate judge. I don't know. And without trying to dodge work, I'll let y'all set this for hopefully not too far into the future. You might keep in mind that Judge Ellison was a probate judge for 6 years before he became a district judge. So he will be a lot more familiar off the top of his head. I'm getting to be one of those old guys that can tell you what the probate code said, but I have to go and look it up to see what the state's code says, because I don't know. So I do that. All right, so do you want to go ahead and set a date right now?
We talked about March 30th, but I don't know whose docket that is.
It's Judge Ellison's. It's Judge Ellison's, but honestly, it's getting kind of full. I don't know if the 31st or April 1 will be better. There are not as many cases on those two dockets. Those are both with Judge Ellison as well.
Okay, well, I will let y'all in the court coordinator's office, court administrator's office, work that out.
Thank you, Judge.
Thank you, Judge.
What dates did you say, Ms. Riley?
March 31st and April 1.
Between those dates, I have a conflict on the 31st. I'd be happy to go forward on the 1st, though.
Okay, if someone will post that to everyone in chat, so we have a written record, and I'll put 4-1 and Mr. Finkel to file objections.
Yes, I'm available for 1.
All right, and Ms. Tapia, have you talked to the attorneys on the Clemens case?
I texted, Mr. Garcia texted me, and we had agreed just to reset it to get some more information with regard to the will.
That's correct, Your Honor. I have no objections to resetting this, and then allow me to talk to the ad litem, and we can get the information from the will and proceed forward accordingly.
No objection from the intervener, Your Honor.
Okay, so is that reset on request, or are you going to pick a date?
Reset on request, Your Honor.
All right, then you're excused, or.
Thank you.
Yeah, but.
Thank you, Your Honor.
Attorneys are excused. Okay, Briand, where do we stand?
Your Honor, I conferred with Ms. Bryan, and there are a couple of issues that she would like the court to address that that we're not in agreement with.
Okay, and where do we stand on the Aguirre children? Are they still conferring?
Still in a breakout room, Judge.
Okay. All right, let me try and pull the whatever pleadings we have on this case.
I'm sorry, Judge. We posted the reset date in the chat, and they would be excused.
You're excused. Have a good day.
All right, thank you, Your Honor.
We'll be in touch.
Okay. Let me ask the parents to unmute their electronic devices.
Chris, you need to appear.
I'm here. I'm here.
Okay.
Okay, let me ask the Brians to raise their right hands. Brian's. Each of you swear or affirm the testimony you may give in the matter now on trial will be the truth, the whole truth, and nothing but the truth, so help you God.
I do.
All right, Ms. Bryant. I did not hear a response.
Yes, I do.
Okay, all right, and your name, please, ma'am?
Lorena Bryan.
And your name, sir?
Christopher Bryan.
All right. Are both sides ready?
Yes.
Yes, Your Honor, we're ready.
Go ahead, Ms. Tapia.
Your Honor, I'll just narrow the issues. As you know, we filed pleadings to reduce the child support based on minimum wage. Mr. Bryan currently has 3 children. There's one before the court in this matter. Child support based on minimum wage would be $182.75 a month. Currently, the child, Rylan, is not covered under any health insurance. There was a miscommunication, is my understanding, as to whether he was to be covered under Medicaid or Miss Bryant. I believe she just started a new job. So my client will be covering Ryland under Medicaid. And then the other issue is that I discussed with Miss Bryant was she's seeking out orthodontic treatment for Ryland. My client has stated that he would help out as he could, but he could not commit to the monthly payment that would be required for the next 18 months or the half of the deposit. And then the other issue was that we are asking that it be retroactive, the child support be in effect retroactively, which would be to when Ms. Bryan was served as of December 6th. And Ms. Bryan wants it to be effective with the April 1st child support payment. And that's basically where we're at, with basically the court deciding with regard to the orthodontic treatment and then whether or not the child support would be retroactive.
Okay, does Mr. Bryan owe any arrearage right now?
Well, depending on whether it's retroactive or not, the last payment that he made, is my understanding, is the November child support payment. As far as a complete payment, as far as partial payments, I didn't ask my client if he'd made any partial payments.
All right, Judge Ellison signed an order in December of last year, about 90 days ago, and your client had an arrearage of over $6,000 at that time.
Correct, Your Honor. And the payment was, that was supposed to be the $607 a month. And the arrearages would be confirmed, and again, it would be added into this as well. Whatever arrearages that are remaining.
Okay, so how much does your client owe?
I would have to calculate that. Where did the order go? I'd have to find that, Your Honor. I'm sorry, I don't.
But he hasn't miracled up.
I'm sorry, Your Honor.
He has not miracled up a payoff for that amount.
No, Your Honor.
All right, Ms. Bryant,
Yes, Judge.
what are you wanting me to do this morning?
I do not believe it's fair as far as, reducing the child support. We've been coming back to court so many times. He's still not employed. I don't know as far as the, if he's even trying to work. I'm not too sure. As you can see in the file, you know what I mean? And he's been on probation multiple times, violated probation. So, I mean, as far as going down to minimum wage, at this time, am I completely okay with it? No. And as far as the whole orthodontic, work, medical insurance, he doesn't have medical insurance. He doesn't even want to agree to half of the deposit for Rylan to get orthodontic treatment. So it's, I just, he's giving nothing for me to work with, I even, I know Ms. Tapia mentioned, as far as, lowering the child support and all that. And I even said, all right, well, if we do that, can we at least do, taking, in consideration, his payment, right? 607 from December, January, February, March, which would come out to 2428. And he mentioned it to Chris. He said, no, they can't do that either. So it's like, they can't do that. He still can't hold a job, doesn't want to agree to orthodontic, treatment. He doesn't even have them covered right now under medical insurance. So it's like, not giving me anything to work with.
And Your Honor, just to clarify again, my client said that they would help out, he would help out as he could with regard to the orthodontics, and he doesn't have a problem doing that. And again, the medical insurance was a misunderstanding, a miscommunication, and he will have the child on Medicaid by the end of the week, whatever it takes to get him on to Medicaid. So it wasn't because of not wanting to do it or disregard for anything. And then I know my client had one of his SSI hearings yesterday, which he can testify to that as far as what was said in that, if the court would like to hear testimony about that.
So was your client put in jail in December?
Yes, Your Honor, he was.
How did he get out?
You had, he made a payment, a lump sum payment, and you had him in there for, I believe it was approximately 2 weeks. And he had to come back on, I believe it was December 18th. And you said depending on what kind of payment that he came up with would depend on whether he was going to go back into custody or he would be released. And he made a lump sum payment, and you allowed him to be released. Or was it, I don't know if it was you or Judge Ellison. I'm sorry, Your Honor, it was a while ago.
And has Mr. Bryant made any payments since he was released?
Mr. Bryan, have you made any payments since you were released in December?
$400.
$400?
Yes.
And when did you make that payment?
It was last month.
That's not true. I haven't received a payment ever since he made that payment to give it.
Was that payment mailed to the Child Support Disbursement Unit?
Yes, yes.
Does he have proof of that? I haven't received a payment since November.
Give me just a moment. And are we missing something in the district clerks? Because the last thing I see, it looks like it's an order from Judge Ellison. Putting him in jail. Mr. Bryan.
Let me see.
Amended order revoking suspended commitment.
I'm showing, right, amended order revoking suspended commitment. It shows that he is committed to 180 days, but that it's suspended for 120 months. Is what the order that I have, Your Honor.
Okay, what page does it say it's suspended? Or what is
On page 2. Maybe that is.
That's what he was on, because this says that this is the order revoking that previous suspension of his sentence.
Yeah, the order that I have is it was December 16th, or it was December 15th, signed and filed on December 16th. And that was the last time that we were in court on the enforcement.
And as far as payment, the last payment was 12/18/2020. And that's on the Attorney General website. I can send you a picture of that if you like, Ms. Copy.
Okay. Total of 66.7.
Because it says he's committed, confined to the Karnes County Jail until he pays $1,090.
And I believe he paid that day.
Okay, I will reduce Mr. Bryan's child support to what he would owe with the number of children he has for minimum wage, effective on the first of the month after the month in which he becomes current on his child support.
Okay.
So if he pays off his arrears this month, that'll be the first of next month. If he never pays it off, it'll be the first of never.
$1,200 to Lorena right now,
I win.
by the first of never.
So, okay.
All right, so do you want to work on that order?
Yes, Your Honor, I'll put that order together.
Okay.
Judge, I have a question, if you don't mind.
Yes, ma'am.
In regards to his medical insurance, he's not covered as he's supposed to be covered. And as far as the orthodontic work, I was asking for half of the deposit, which is $250 for him to get started on orthodontic treatment. And then I did send Ms. Tapia the page, you know, that gives a breakdown. Supposed to be a total of 18 months for the treatment, which comes down to $75 a month for 18 months.
Okay, what does the current order say on things that aren't paid by insurance?
He's supposed to cover, go ahead, Ms. Tapia.
So just for medical, it's supposed to be half. As far as dental, it's basically just the standard provisions, and then orthodontia is not covered in dental, as far as dental insurance premiums or anything like that. So.
All right, Ms. Bryant, I don't have a motion to modify from you in front of me and I don't have a motion to enforce from you in front of me. I can't just jump up and start making rulings. I have to have.
Okay,
Yeah,
that's fine. I'll
do
go
that.
ahead and
I mean, you're not getting the money he's supposed to pay. I don't know that you're going to get any more. I mean, I wish you good luck with that, but.
And I can put in the order, Your Honor, that the child needs to be covered by Medicaid within 5 days from today's date. If
certainly, because yes, that's a violation.
Okay.
And as far as the amount that he owes, since the last payment I received, it was in 12/18 of last year.
All right, and again, Ms. Bryant, I don't have a motion to enforce against him pending, but what I have ruled is that his child support won't go down until he's current. So hopefully that will motivate him to get current. If not, then you're going to have to either yourself or with an attorney file another motion to enforce.
I will do that. Thank you.
Thank you, Your Honor. I'll put that order together and circulate it to Ms. Bryan, and then I'll submit it to the court.
All right, and Ms. Bryan, Ms. Tapia is going to send you a proposed order, and she's not asking you to agree to the order. She's asking if you agree that the order is what I have ordered.
Thank you.
Okay.
And if not, then we'll have to set this for a.
Okay.
And have that entered. Okay. All right, y'all are excused.
Thank you, Your Honor.
All right, in the interest of the Aguirre child.
Yes, Your Honor, here we are. We've conferred, we do have an agreement on most of the issues. The only thing we're not agreed on is child support. And we would probably need about maybe 30, 45 minutes since it is an interpreter is required.
Okay, everyone should have interpretation down at the bottom. Mr. Ramos was sworn in previously.
Your Honor, I don't think I received that.
The invite?
Right, to be the interpreter.
I may not have done it correctly.
I have an interpreter button.
Can
Could you unmute them? And yeah, and see where it says interpretation right there. Make sure it's on Spanish.
Mr. Ramos, can you give me your email so I think I have to plug it in here. I
Oh,
believe.
yes, let me,
Or maybe I'm not doing this. Hold on one second. Let me try again. I've never done this before. Not joined. Really don't know what I'm supposed to do here. Oh, here it is. I think I've figured it out. Hold on. Hector Ramos. Okay, I think that may have done it. I'm not 100% sure.
And it would have came from an email from you, Ms. Walls?
Is that correct? Judge, do you know?
Yes, ma'am.
It has to go to Mr. Ramos.
I sent it to him, so I don't know.
I can't hear him, so it sounds like perhaps it is.
Okay.
Yes, I just selected English. Has everyone selected either English or Spanish? Okay. No, it's Mr. Aguirre, actually. What is his name?
Juan Aguirre.
Miss Magana also needs an interpreter.
Come in.
Okay, and does she have Spanish selected?
Yes, Your Honor.
Oh, yeah. Make sure it's not muted. Your Honor, they can't hear? Yes, Your Honor, we're checking on that. Let me go see what's going on. I had my assistant put them in, but for some reason, let me go check. Yes. Okay, they can't hear, they can't transmit. Maybe that we need to exit and come back in. That's the only thing I can think of.
Okay, do you have Spanish selected for the language?
Yes, yeah, we do, Your Honor. We do.
Okay, then whatever you need to do, do it. All right. Ms. Rojas Moore, is your client?
Thank you, Your Honor.
In Spanish?
Yes, Your Honor, she is. She has selected the Spanish button and yes.
Okay. I'm not sure that Mr. Aguirre is selected correctly because he lit up and turned yellow when he said something, and I don't think I should have been able to hear him if he was on the Spanish channel.
Hey, not on Spanish channel. We can't hear.
Are you going somewhere nice for your birthday, Lachey? Happy birthday.
Yes, happy birthday, Lachey.
Thank you. Yes. Going to dinner.
Excellent.
Okay, can you hear us?
Yes.
Now it's coming out here. Now it's coming out on my laptop in the other room.
Okay, what language do you have selected on that computer that you're on now?
I'm sorry, Your Honor, I was in the other room. I didn't hear you. Let's see, what did we do last time? We had this problem when we went into the conference room. We just, I'll try to switch the laptop, but I don't think that did it.
Okay, what language?
Can you hear me?
Yes, we can hear you. What language do you have selected on the other computer?
Spanish.
Okay.
Spanish.
All right, and did anybody speak to Mr. Aguirre in Spanish, Mr. Ramos?
The problem is the transmission's coming over here, but it's not going over there to his room.
The translation?
The audio transmission. In other words, when he's up, it comes out here instead of in his.
All right, sir. All right, so I'm not sure, but I understand what you're saying.
Okay, I'm in one room, I'm in the office, he's in the conference room. So I opened, we went back in, okay? But the audio is coming out here in my office, not in the conference room. Not sure why that is. On both. I think it's. Hold on, let me check. Okay, sorry, we got it. We fixed it.
Okay, but I can hear you on the English channel, so we need to switch that computer to Spanish.
See. Yes, it's working.
Okay. But we can hear Mr. Aguirre when he's speaking.
Juan Aguirre?
Yes. Okay.
Okay, Jorn, I think we're ready.
Okay. All right, I don't even know who is the.
Mr. Flores is
Are you
petitioning.
the petitioner? Okay. Let me ask, first of all, are both sides ready in 27-120 in the interest of Christian Aguirre, a child?
Yes, Your Honor.
Your Honor, Aida Rojas Moore, on behalf of respondent Ms. Magana, we are ready to proceed.
Okay.
Renee Flores on behalf of the petitioner, and we're ready to proceed also, Your Honor.
Okay. Now, let me ask Mr. Flores, what is it that you have an agreement about before we get to what you don't have an agreement on?
Okay, we have an agreement, a mutual, that number one, there's going to be a standard possession order for the child. And with these conditions, the child will sleep in his own room whenever possessed by either party, or on his own bed at the very least, not on a sofa. We will provide, as required by law, the current address, and we've already provided to opposing counsel. No alcohol, 12 hours before custody, and no use of illicit drugs, and that's a mutual order also. We have agreed to a follicle test 2 times a year, randomly requested by the respondent, but she will pay for it in advance. we have agreed to give the mother, even though we're asking for JMC, we're agreeing to JMC, the mother will have exclusive right to medical invasive procedures, educational, psychological, and psychiatric treatment. That both parties shall sign whatever is necessary to secure the child a passport, and neither party can refuse except for reasonable, legitimate reasons. And I know there's some arrearage. We've agreed to $25 a month for him to try to catch up with that. And it's only 1 month in arrearage. Well, 2 months, but he's going to pay what he owes this month, this Friday when he picks up the child.
Your Honor, may I clarify some of those agreements?
Yes, ma'am.
It has been agreed that father this Friday will pay $600 directly to mother. Our intention is to set up the child support with the Office of Attorney General so that payments can be made through that system. There is, parties will split any unpaid medical 50-50. There is also, just want to make very clear that there is no alcohol 12 hours before and while in possession of the child, and there is no illicit drugs 12 hours before or in possession of the child. We're hoping there's never any illicit drugs by either party at any time, but we're trying to hone that down. The follicle test, Your Honor, is 2 times a year by mother to pay prior to the test, or father going to the facility for that test. I believe those are the only things that I need to kind of clarify.
Okay. All right, go ahead, Mr. Flores.
Yeah, the only issue now is the child support, Your Honor, and they want him to continue to pay the $600. We're saying that his income has gone down because of the pandemic. He's not working as much. He has basically doesn't have the same job and the same responsibilities. So he got a reduction in pay. So we're asking for the child support to be in accordance with the basically what is required under the law, which is essentially $256 a month.
And if I may respond, Your Honor, during temporary orders, it was agreed that father would be paying $598 a month. He is clearly behind now. Subsequently, I was just informed by Mr. Flores, Mr. Aguirre's counsel, that Mr. Aguirre voluntarily demoted himself from his position. I just got that information from his attorney this morning. And I would be arguing, Your Honor, that now he is underemployed, purposely underemployed for the purposes of decreasing his child support. And we are still asking that child support be maintained at $598 as previously agreed. We believe Mr. Aguirre is purposely trying to diminish income for the purposes of child support.
Okay. All right, which witnesses do we need to have sworn in?
My client will testify, Your Honor.
And my client, Your Honor, at this time.
Okay. All right. May I ask the parties to raise their right hands? Do each of you solemnly swear or affirm that the testimony you may give in the matter now on trial will be the truth, the whole truth, and nothing but the truth, so help you God?
I think he's on mute again. I don't know why.
Yeah.
Can you unmute him? My assistant's about to unmute him.
All right, I have not heard any response from,
He's on mute.
and I have not heard a response from the respondent. I saw a yellow box light up, but I still haven't heard anything from respondent.
Hey. No. See. You might want to repeat it.
Okay. Were both
Magaña?
parties? Go ahead, ma'am. Okay. Somebody has multiple computers going on where they can hear each other. That has to be shut off immediately or we'll never get this done.
We can't hear each other, Your Honor. I'm in a separate room, door closed.
Okay.
He replied, but earlier.
I don't have no idea what he replied to.
Us? Okay, he replied. Okay. He replied.
Mr. Aguirre, can you hear me?
Sí.
Yes, sir.
Make sure it's on Spanish.
Yes, I just changed that.
Okay.
Okay. He responded, Your Honor. He can hear it in Spanish.
All right. So let me ask one more time. Do both of you solemnly swear or affirm that now on trial, the testimony you will give will be the truth, the whole truth, and nothing but the truth, so help you God?
Sí.
Sí.
Put your hands down. Go ahead, Mr. Flores.
Okay. Mr. Aguirre, can you please state your full name for the record?
Juan Aguirre Lopez.
Okay, Mr. Aguirre, we have one issue in this case, and that's the child support, and it relates to how much you're earning now. Can you tell us how much you're earning now, more or less?
A 8.50 la hora.
Okay, how many hours a week do you work? Oh, sorry. And how many hours a week do you work?
Mr. Flores, let me interrupt you.
Uh-huh.
Okay. I need to talk to both the mother and the father. When you're using the interpreter, please answer in Spanish as if there were no interpreter. By that, I mean the court reporter is making a record of what everyone says. So you will answer in Spanish. Everyone can hear what you're saying in Spanish, and then the interpreter will interpret your answer into English to go down into the record. So don't respond to a question saying, tell him that, and then the answer. Just answer directly in Spanish as if you were speaking directly to whomever is asking the questions, okay? All right.
May I proceed, Your Honor?
Yes, sir.
Okay, how many hours a week? Yeah, thank you. How many hours a week do you work?
40.
Okay. Okay. Do you get any overtime?
No, ahorita con lo de la pandemia no.
Okay. Okay. And you, when did you start making $8.50 an hour?
Hace como un mes y medio.
Okay. Okay. And why are you making less?
porque ya no me están dando horas, no hay mucho trabajo y tengo que empezar a trabajar. Pues, de trabajo, ya había dicho en la otra audiencia, tuve que empezar otra vez desde abajo.
Okay, so are you, what's your position there at the restaurant? Just- He's back on mute for some reason. I don't know what's going on.
I've asked him to unmute twice.
Yeah. Let me have him on mute.
Yes, sir.
Never mind. We get it?
I think so.
He's still frozen though.
Sí.
What's your position at the restaurant?
Pica verduras.
I'm not familiar with that term. Oh, good. So you're a cook?
Sí.
Okay. And
All
this
right.
is,
Wait, Mr. Flores, we're getting feedback.
sorry, Your Honor, sorry.
Is the door still shut?
Yes,
Okay, could we perhaps turn the speakers down a bit?
pardon me?
Could you perhaps turn the speakers down a bit on Mr. Aguirre's side? Or somewhere, because we're getting feedback whenever he speaks.
Turn the speakers down?
Whatever it takes, so that the reason we're getting feedback is that the sound is going from one of your computers to the other of your computers. And it's not happening when you're speaking, it's happening when Mr. Aguirre is speaking.
Can you turn his sound down a little bit, please? Thanks. Okay, they're gonna turn it down. Okay.
Go ahead, sir.
Okay, I'm sorry, I lost my place here. You're a cook, is that correct?
Sí.
Okay. And you work at Agave Jalisco Mexican Restaurant in Kennedy, Texas?
Sí.
Okay. Is that better, Your Honor? The volume, the feedback?
No, but go ahead.
Okay. So before you became a cook, what position did you have at the restaurant?
Antes era encargado.
Okay. And how much were you making at that time?
9.50 la hora.
Okay. So you used to be the manager?
Objection, Your Honor, leading the witness.
I'll overrule the objection. Go ahead, sir.
Do I repeat the question?
I don't care.
Yeah. So you used to be the manager of that restaurant? Do you need me to repeat it?
He's vanished from my screen.
Did you? Come in. Just stand there. It keeps.
Here's the question. He's answering with that one.
It's muting. It keeps muting itself. I don't know why. Stand there and make sure it doesn't happen. Sorry, Jan. I'm gonna have my assistant stand there. I don't know why it keeps muting.
Or Mr. Flores, your audio and video are very choppy also.
I can try to switch devices, Your Honor. That's all I can do.
Okay, if you think that will help, go ahead.
Okay, well, let me leave the room and then come back on my iPad. Honor, can you hear me?
Yes, sir.
Okay. I have to switch to my phone because
Okay.
I just
Right.
can't figure it because it's a phone. I'm
Okay.
trying to. Okay. If you give me a minute here, I'm trying to figure out how to go to English in my hand on my phone. Does anybody know how to do that with an iPhone? Switch to English, put it on the channel. Because I don't see a button. Okay, Mr. Ramos? I can't hear him.
Mr. Flores, can you hear Mr. Ramos?
No, I cannot. I don't know how to switch it on my iPhone. I don't know how to get the channel. Oh, hold on. Oops. Sorry. Does anybody know how to do it on an iPhone? Can you get Rosa in here, please? Sure. I got a young person involved. We figured it out. I got it, Your Honor. Sorry.
All right, go ahead.
Okay. You previous to you being a cook, what was you mentioned that you were a manager?
Sí.
Okay, and so why did you go from being a manager to being a cook?
Porque era mucho trabajo y luego no había gente, no me pagaba bien. Entonces decidí cambiar de trabajo. Mucha responsabilidad.
And what do you mean they weren't paying you what you were supposed to be?
Porque no había gente, no había ventas. Con lo de la pandemia, pues no hay mucho trabajo. Nadie quiere salir.
Okay, so you were working less hours.
Sí.
Okay. How many hours were you working?
Pues ahí como
Typically-
eres manager, pues tienes que...
How many hours were you working when you were a manager?
80, 85, pero no...
Is that a week?
Sí, porque un manager tienes que ser responsable todo el día, falta o no falta gente.
Okay. And how much were they paying you per hour?
9.50.
And so did you purposely take a pay cut then to pay less child support?
No,
Okay. But you knew you were paying at the time $600 a month. Why did you take a pay cut then?
porque tengo que buscar otro nuevo trabajo. Si allá me pagaban, me salía bien, pero era de las ganancias, no es mi sueldo. Si quedan ganancias, gano, si no, no gano.
So were they paying you all the hours they owed you as a manager?
Sí.
So why do you say that they didn't pay you what they were supposed to?
No me conviene, pero pues no hay ahorita, como ahorita no hay más trabajo, pues tengo que buscar lo que encuentre.
Okay. Who's the manager now at your restaurant?
Otro muchacho, no sé cómo se llama.
You know, I have a exhibit. I know that the opposing counsel is going to object to, but on my iPhone, I'm not sure how to pull it up.
I don't believe you can on an iPhone. And that's
Yeah.
my experience.
Yeah, but it's basically a letter from the employee about how much he's making. And I know.
I'm going to object. I just don't want him to go into hearsay, Your Honor. So if he's going there, I would object to him saying anything about what's in the letter.
Okay. Mr. Flores?
Your Honor, I just think it would be helpful for the court to get some proof of what he's been testifying to. Basically, you know, well, I'm not going to say.
Well, it might be, but does it come under a hearsay exception?
Record kept in the course of business.
Your Honor, there is no affidavit of business records filed with the court. The person who wrote the letter is not here to testify. I would like the opportunity to cross-examine. It is still hearsay.
Okay, I'll sustain the objection.
Very well, Your Honor. I pass the witness.
Mr. Aguirre, I just have some questions for you. How long have you been receiving pay stubs from Agave Restaurant?
Estaba recibiendo antes.
Well, let me ask you another question. When did you start working for Agave Restaurant?
Todavía estoy en los mismos agaves. Nomás cambié de diferente restaurante.
Mr. Aguirre, how long have you been working for Agave Restaurant?
No. ¿2 años?
Okay. Now, sir, in the 2 years, isn't it true that you have received paychecks from Agave Restaurants since you started working?
Empecé, me estaban pagando con cheques cuando era manager o trabajaba más tiempo.
Okay, sir. When did they start paying you with checks?
Cuando empecé a trabajar.
Okay, so Mr. Aguirre, why is it that you have failed to provide my office with any paychecks evidencing your income since you started over 2 years ago?
Que no los tengo, los talones de cheque. Los talones de cheque se los llevó Nayeli Magaña.
Now,
Ella los tiene.
did you cash your paychecks, Mr. Aguirre? Yes or no?
No, los cambiaba Nayeli Magaña.
Mr. Aguirre, why have you, through your attorney, repeatedly told my office that you only get paid by cash and you don't have evidence of your income?
Últimamente me están pagando en efectivo, pero antes, cuando me pagaban en cheque, Nayeli Magaña tiene los recibos, ella se llevó los comprobantes.
Mr. Aguirre, how long have you been a cook for Agave Restaurant?
Cocinero tengo 2 años, lo del tiempo que llegué, siempre he sido cocinero.
Okay, and when you entered into an agreement to pay $598 in child support, you were still a cook, weren't you?
Sí.
And sir, during that time, you were getting paid, correct?
Sí, me estaban pagando bien.
And isn't it true, Mr. Aguirre, that you, on your own accord, decided to demote yourself prior to hearing?
No es por antes de la audiencia, pero si no estoy ganando bien, pues, ¿qué estoy haciendo? Tengo que buscar otro trabajo.
So let me ask you the question again, Mr. Aguirre. Isn't it true that before today's hearing, you asked your employer to demote you? Yes or no?
No, yo tengo más de 2 meses que se me entregué ese puesto. Desde la otra vez de la audiencia, yo había dicho en la audiencia que yo había cambiado de trabajo. No tengo días.
Mr. Aguirre, when you said that now you're making less money, you asked your employer to give you less money, didn't you?
No, ¿cómo le voy a decir que me den menos? Yo no tuviera problemas si estuviera ganando el mismo dinero para darle el mismo child support. ¿Cómo voy a pagar el mismo child support si no estoy ganando el dinero?
Mr. Aguirre, you were making more money back in August all the way through about a month ago?
Hace 2 meses, va a ser 2 meses. Que fue el día de la última vez de la audiencia.
So Mr. Aguirre, you're behind in child support, aren't you?
Sí,
In the last hearing, you were behind in child support, weren't you?
sí.
And sir, at this time, since the hearing, you've gotten married, is that correct?
No, tengo 6, 7 meses. Desde agosto todavía me casé.
Okay, so you're married and your wife has children, is that correct?
Sí.
How many minor children under the age of 18 does she have?
And I'm gonna object to the relevance of this questioning.
Your Honor, it is very relevant that he's choosing to reduce his own personal child support for this case, knowing that he married into a family, now he has to support as well. And I think he's being misleading with this court that he didn't do it to reduce child support. I think it's very relevant.
I'll overrule the
Okay.
objection. Go ahead.
You can answer the question, Mr. Aguirre. How many children under the age of 18 does your present wife have?
Dos, pero uno no vive con ella, vive con su papá. Perdón. Voy a hacer
So she pays child support, correct?
Sí.
So
Perdón.
you have incurred, after getting married, you've incurred additional expenses for a new family, haven't you?
No, yo no pago nada para ellos. Yo pago mis cosas. Sus papás de ellos pagan los gastos de ellos.
So you don't support these children at all. Is that what you're telling this court?
No, mi esposa para eso trabaja, para mantenerlos a ellos.
I see. Now, Mr. Aguirre, when you said that you asked earlier, your attorney asked you about reducing your work that you needed to make or that you were working too hard. Do you remember that? You told this court that you were working too hard and there wasn't enough business, so you wanted to change your position. Is that what you told this court earlier?
Sí.
Okay. So you went to your employer and asked him to give you another job within the restaurant. Is that true? Is that true?
Pero si tú empiezas en un lugar, a mí como, si tú me vas a dar trabajo, yo como voy a empezar de patrón, tengo que empezar a trabajar desde abajo, no voy a llegar a quitar nomás a alguien más.
Okay, Mr. Aguirre, did you understand my question?
Sí, es que en el mismo restaurante son diferentes. Estaba en Ronge y me moví para Kennedy. Y no voy a llegar a trabajar de gerente o
You've
manager
always
otra
worked
vez.
at the restaurant in Kennedy, haven't you?
No, estaba de manager, estaba en Ronge. ¿Ronge?
Yes.
Mr. Aguirre,
Huh?
are you working in Kennedy restaurant or is there another restaurant in Ronge?
Trabajaba en Ronge y de ahí me cambié a Kennedy. Y ahorita estoy trabajando en Kennedy.
Okay. Now, sir, just so that I'm very clear, you did tell the court, just so that I'm clear, that you wanted a different job title because there was too much work. Is that what you told this court earlier?
Yo no dije que quería un puesto mejor o quién me va a dar un puesto mejor. Si ella me da un puesto mejor, yo me voy a trabajar con ella, si me va a pagar bien.
And sir, is your employer here today to testify as to your employment and how much you make today?
No, pero ahí
Okay, so
tengo su número de teléfono, puedes hablar con.
So, sir, do you want this court to believe that you're making less money because of pandemic, but during pandemic, you were actually making more money. Do you want this court to believe that you're making less money now?
Pues entonces, ¿qué puedo hacer para que me creas? Puedes venir a mi trabajo, puedes
Okay.
venir a hacer para que veas lo que estoy.
Now, Mr. Aguirre, how are you getting paid now?
En efectivo.
You also want this court to believe that for over 2 years, you were getting paid checks. You were getting paid your income in checks, but now you're only getting paid cash? Do you want this court to believe that?
I'm going to object, Your Honor. You're misstating what he said.
I'm asking a question, Judge.
I'll overrule the objection.
You can answer, Mr. Aguirre. Do you want this court to believe that now you're getting paid cash and now we can't verify how much you're making? You want this court to believe that?
Pero pues, ¿cómo quieres que le haga? Si mi saldo no es muy alto, pues me lo
Your
están
Honor, at this
pagando en
time,
efectivo.
At this time, Your Honor, I'd like to show Mr. Aguirre Respondent's Exhibit number 4 that has already been sent to Mr. Flores.
Mr. Flores, any objection?
Well, I'm going to make the same objection as hearsay, Your Honor.
Your
And
Honor,
not authenticate it.
I can definitely authenticate it if Mr. Flores will show his client in the other room my exhibit. I can definitely authenticate it through him.
All right, well, I don't know what it is, so go ahead and show it on the screen and see if you can authenticate it.
Yes, Your Honor, I will share the screen now. Mr. Aguirre, can you see this check that's in front of you?
Sí.
Are these checks made to you by Agave Restaurant?
Sí. Sí. Y puedes mirar la fecha arriba de
Do
qué
you
fecha
see
es.
there? And is that your signature, Mr. Aguirre?
No, la mía no es José Luis. Mi nombre es arriba, Juan. Sí.
Who is Jose? Okay, was this check made out to you? Jose Juan Aguirre Lopez, right here.
Juan Aguirre López.
Is that you, Mr. Aguirre?
Sí, Juan Aguirre López.
Were these checks made to you by Agave Restaurant, by your employer, Jose Angel?
Huh?
I'm not getting a response, Your Honor. I don't know if you can hear.
Sí. Sí, esos cheques yo los hice, pero en ese tiempo, hace más de un año, estaba trabajando overtime. Magaña está de mañana. Esta Nayeli sabe
And Your
de lo
Honor,
que son esos cheques.
Your Honor, at this time, I'd like to admit into evidence Respondents Exhibit 4 that have been tendered to opposing counsel and clearly identified by his client, Mr. Juan Aguirre, as paychecks for his employment.
All right, Mr. Flores?
Yeah, I'm going to object to hearsay, Your Honor.
Okay, I'll overrule.
And I don't think it's a proper authentication either.
All right, I will overrule the objection, submitted into evidence for Respondents 4.
Thank you. Now, Mr. Aguirre, can you tell me once again why you, through your attorney, refused to give me any checks and inform my office that you were only getting paid cash even back in August of 2020?
Your Honor, I'm going to object to her insinuating that he refused. Nobody's ever refused anything.
I'd like him to answer the question, Your Honor.
All right, well, I don't know, but, so what is the objection? Assuming things not in evidence, or?
Yes.
Okay. So do we have a motion to enforce discovery, or is there, are there discovery responses?
No, Your Honor, we had just an informal discovery between the parties.
Your Honor, we were just shown these checks. I've never seen these checks before. I didn't even know they exist.
Because his client kept telling him that he only got paid cash, Your Honor. That's why.
Okay, see,
we
I
were
don't
able
know
to-
when you said that you started paying child support in August or something,
That's correct, yes.
but this is a 21 case, so the case was just filed in January. Was there a
No,
case?
2020. It was filed in
Oh, am I on the
July.
wrong? Oh, 20 is filed in July. Okay.
Correct, Your Honor.
All right. What I heard Mr. Aguirre say was that your client, ma'am, kept all of his checks or check stubs. That's why you didn't have any from at least before they separated.
I'll move on, Your Honor. Mr. Aguirre, just very quickly, are you looking for another job to get more money?
Sí, pero pues ¿dónde lo encuentro? Ahorita con la pandemia no hay
Where are you?
trabajo.
Where are you looking, Mr. Aguirre?
Pues ¿dónde me pueden dar? No tengo seguro social. No me queda más que trabajar de cocinero o en un lugar donde me van a dar buen trabajo si no tengo seguro.
And for the last 2 years, Mr. Aguirre, you have been working as a cook, correct?
Sí, yo toda mi vida he trabajado de cocinero.
And you have experience in a cook, as being a cook, correct?
Sí.
Now, Mr. Aguirre, during temporary orders, when we made an agreement that you were going to pay $598, you were a cook, correct?
Sí, pero temporales. Tenía buen trabajo.
And you decided that it was too much work for you, correct?
No, pero a ti si no te pagan bien, no vas a trabajar. ¿O quién trabaja a alguien que no le pague bien?
But Mr. Aguirre, you told your attorney earlier that you were still getting paid, didn't you?
Sí, me estaban pagando, pero algo para seguir pagando
Okay,
no se puede.
so now, Mr. Aguirre, what evidence did you bring today that you're only getting paid $8.50 an hour and that you don't have the same position that you had 2 months ago? What evidence do you have?
Pues, ¿qué evidencia tengo? El número del encargado, del manager, hablo con él. Aquí tengo una hoja, se la di a mi abogado. Y ahí tiene el número y él cómo me está pagando todo. Y si quieres hablar con él, habla con él y para que te quites de dudas.
Mr. Aguirre, you have a 10-year-old son, correct?
Sí.
Do you not think that he deserves the same shelter, food, clothing, as the children that are in your home right now that are not your biological children?
Sí, entonces déjamelo tráemelo conmigo y yo le doy todo, le doy techo, le doy casa, le doy comida.
And so
Su
you don't
madre
have to pay
trabaja para
child
darle de
support
comer a
then,
sus
right?
hijos.
Mr. Aguirre, what child support do you want to pay right now because of what you're saying? Isn't it, you're asking the court to reduce your child support to $260 or something like that? Is that correct?
de lo que puedo pagar. Mientras yo, ¿cómo te voy a poder pagar más si no estoy ganando bien o no estoy trabajando todos varios días?
And again, you brought no evidence to show that you've been getting paid cash or checks or anything, did you?
Sí, traje una carta, se la di a mi abogado.
But your employer's not here, is he, Mr. Aguirre?
No.
So the
ahí está,
only thing you want this court to do is to listen to you and believe that now you're getting paid cash and you can't verify how much cash you're receiving, but you know it's less. That's what you want this court to believe today.
No me creas a mí. Te doy el número de teléfono y
further
habla con
questions,
él.
Your
Cree con él. Yo qué te puedo hacer para que me
Mr.
creas.
Flores,
I don't have any further questions, Your Honor.
your next witness.
That we close, Your Honor.
I'd like to question
Right.
Ms. Your Honor.
Go ahead, ma'am.
Ms. Magana, how old is your son?
10 años.
And how much child support have you been receiving since August of 2020?
3,600.
And has Mr. Aguirre been paying you the child support as was agreed back in August?
Sí, debe 2 meses ahorita.
Has he always been behind in child support since we started this case?
No,
Is he behind right now, Ms. Magana?
sí.
Now, have you had any conversations with Mr. Aguirre during the time that he's had possession of your son when he's brought him home?
Sí. Sí.
And has he discussed with you making less money or moving residences or anything of that nature?
Él me dijo que él estaba haciendo más dinero.
When did he tell you he was making more money?
Este último mes.
Okay. And what was the occasion? Where were you? What conversation? Was he dropping off your son or what?
Sí, cuando él va a recoger al niño.
Now, has Mr. Aguirre always been a cook?
Era cocinero, pero era encargado también. Él recibía dinero en efectivo y dinero en cheques.
And you heard Mr. Aguirre talk about that he had not seen the checks or he didn't have any paychecks to give us because you had them. Is that true?
Esos últimos cheques que mi abogada presentó fue los que yo le presenté a la abogada porque fueron los últimos que yo tuve para poder presentar, pero él era el que cambiaba los cheques porque obviamente necesitaba su firma y yo no estaba incluida en su cuenta.
So the checks that we saw that Mr. Aguirre says he didn't know he had and he couldn't give to us, would he deposit those into his account?
Sí, claro, todos los cheques se depositaban en su cuenta.
So when he tells this court today that he couldn't get the checks or he didn't know about the checks, in your opinion, do you believe he was being honest with his court?
No, claro que no, porque sí le pagaban con cheque y él lo sabe.
So when he told you this past month that he was getting more money at his employer, does this surprise you today that he's telling this court that he makes less and he wants to pay less child support?
I'm gonna object to leading, Your Honor. She never said last month.
Sustained.
Ms. Magana, hearing Mr. Aguirre's testimony about not being able to pay $598, does that surprise you?
Sí, la verdad, sí.
Why does that surprise you?
Mi sorpresa es porque él sabe que nunca se ha quedado sin trabajo. Él sabe que desde que nos movimos a ese lugar, él siempre ha ganado bien. Desde que nos separamos, él siempre dijo que se iba a ser responsable de su hijo y que nunca le iba a faltar nada. Él dice que por la pandemia, yo solo quiero comentar algo, yo me quedé una semana sin trabajar y él está atrasado en su pago de manutención, pero yo no he dejado sin comer a mi hijo, porque primero es la responsabilidad de un hijo.
Do you believe, Ms. Magana, that Mr. Aguirre is being responsible for his son by asking this court to reduce his child support, although he can't prove that he's making less money?
Exacto, no se me hace correcto.
Does your son have any special needs? Does he have any medical conditions that need special attention?
Yo se lo hice saber a él, desde que él lo sabe, desde hace 4 años mi niño tuvo una cirugía, le quitaron un tumor de su cuello, gracias a Dios salió bien, pero desde esa cirugía mi niño sigue teniendo citas con sus especialistas. Yo le he comentado de las citas, mi niño ha estado hospitalizado, él nunca se ha presentado, yo soy la que me he hecho responsable. Hace poco le mandé un mensaje por texto avisándole que el niño salió mal de su vista también. Le dije que yo necesitaba el dinero porque yo soy la que lo muevo. O sea, son muchos gastos. Yo sé que el Medicaid cubre sus gastos, pero no solo es los especialistas. Es todo lo que mi hijo necesita. Hasta el momento no me ha mandado un mensaje para saber cómo está su hijo, qué especialista lo va a ver o qué va a pasar. Él no se hace responsable ya de nada.
Do you believe that the child support, according to what Mr. Aguirre is asking for, in the amount of $263, is that enough to support your son?
Obviamente no.
Do you believe Mr. Aguirre is actually making more money like he told you?
Sí, claro, él siempre ha ganado bien y él lo sabe.
Now he has a new family. Do you believe Mr. Aguirre, as he's saying that he doesn't support that family?
I'm gonna object, Your Honor. It calls for speculation, lack of foundation, personal knowledge.
I will clarify my question.
Go ahead.
Has Mr. Aguirre ever told you that he is not supporting the 2 children that are in his home?
No, no me ha dicho, pero, o sea, si
Have
viven
you
ahí,
seen Mr. Aguirre with the children or providing necessities to the other children that he's not providing to your son?
no lo he visto con mis ojos, pero sí viven ahí en el mismo techo, les tiene casa, les tiene un cuarto a cada quien. Mi hijo dormía en un sillón, en un colchón.
I'll pass the witness, Your Honor.
Mr. Flores.
Thank you, Your Honor. You said my client said he was making more money. Is that correct?
Sí, claro.
Okay. But he didn't tell you how much more money, he didn't specify, did he?
No.
And he didn't say making more money as opposed to what? Did he?
Él solo me dijo así.
That's all he told you, correct?
Sí, él se movió a Rongi porque él era encargado y le ofrecían más dinero. Él no ha sido solo cocinero, él era encargado también.
Okay, and he was making more money when? Several months ago? When did he tell you this?
Él está hace en la visita, en la última visita, déjeme checar el calendario. El 5 de febrero, el 6 de febrero que regresó el niño.
Do you know if at that time he had, you don't know if at that time he had switched jobs yet there at the restaurant, do you?
No, porque él me decía, a mí me decía, estoy en Kennedy, después decía que en Rongi, mi niño fue el que me dijo que su papá vivía en Rongi y trabajaba en Kennedy. Porque
I'm gonna object. I passed the witness, Your Honor.
I have no further questions for this witness, Your Honor. We rest.
Mr. Flores?
I'd like to recall my client briefly, Your Honor, for just rebuttal to the issue of making more money.
Your Honor, I would object. He's already closed and rested.
Okay, I'll overrule that. Go ahead, sir.
Okay. Hello, Mr. Aguirre.
Sí.
Okay, you heard Nayeli testify that you told her you were making more money.
Yo en ningún momento le dije, yo cuando las veces de hora de la última audiencia, siempre ha llevado a mi esposa conmigo. Y hasta ella sabe bien que yo nunca he hablado con ella ni le he dicho que gana más dinero o que me ha cambiado de trabajo. Yo desde la otra audiencia dije que ya me había cambiado de trabajo. Yo con ella nunca le dije. Yo nunca le dije, además, ni al hablar con ella o mandarle un texto, es para seguir discutiendo o estar peleando. ¿Cómo voy a visitas a ver al niño si en la otra audiencia está diciendo que yo me lo quise robar del hospital? Yo cómo me voy a hacer cargo o cómo voy a ir a las visitas si diario que voy es como puro pelear, puro discutir.
Objection, Your Honor, non-responsive to the specific question asked.
And
Okay, just answer the specific question here, Mr. Aguirre. So you never told her that you were making more money. Is that what your testimony is or not? So no means you did or you didn't?
Objection leading, Your Honor. I think it's been asked and answered.
Overruled.
I'm just trying to clarify.
I already overruled the
Tengo testigos.
Okay. So did you ever tell her you were making more money?
No,
Yes,
yo
sir?
nunca le he dicho eso y tengo testigos. Mi esposa siempre ha ido conmigo a levantar al niño.
All right. I passed the witness, Your Honor.
I have a question, Your Honor. Mr. Aguirre, isn't it true that you actually, this last time that you dropped, it was on March the 5th, you actually had a conversation with Ms. Magana regarding medication? Isn't that true?
Sí.
And just now you said that you bring your wife all the time and you don't have conversations with Ms. Magana. So which is it? Do you have conversations or not?
Ella me manda textos. O yo cómo voy a ir a ver al niño. Si siempre es para que me dice, me está acusando que yo me lo quise robar del hospital. Yo cómo voy a ser responsable o
Objection,
cómo voy a ir.
non-responsive, Your Honor.
Sustained.
That's all I have for this witness.
No further questions, Your Honor.
Anything else from either side?
Nothing else, Your Honor.
Nothing else, Your Honor.
Okay. There's some things I'd like to know, like whatever income Mr. Aguirre allegedly had last summer, was that hourly? Was that as a percentage because he was a manager? Was that some base plus some percentage? What was that income?
Your Honor,
Is that a question for the attorneys, Your Honor, or for Mr. Aguirre?
For whomever can shed light on it.
Well, Your Honor, that is the first I've heard that he gets some kind of commission or whatever. My information from Mr. Flores was that he was getting paid hourly. And initially there were no checks, but all of a sudden today he remembers now that he got checks. So,
Your Honor, that's not true. I provided checks. That was the whole basis how we decided to pay child support in the last time.
no,
We provided, yes, that was the whole basis.
no.
I provided a number of checks.
Your Honor, our closing argument is that he's purposely he's underemployed. He purposely, right before hearing, decided to demote. Even his attorney used that word, to demote himself. And he said that there was too much work. Fathers shouldn't do that, Your Honor. They have a responsibility.
They have a responsibility to work 80 hours a week?
No, Your Honor, there is no evidence that he worked 80 hours a week. His employer has never, even for the agreement that we had, all they had to do is bring his employer, how many hours, give me your pay, whatever. No documentation, Judge, nothing.
All right. What do you believe, what's your position that Mr. Aguirre's hourly rate is?
Whatever we agree to at temporary orders, Judge, the $598 is what he was gladly to pay, and he would not produce any documents. And we agreed to that. That number came from them, not from us. We agreed because he was saying to us that he was getting cash. How can you prove cash? They agreed to that. And now they're saying, oh no, but wait, now we're still getting paid cash, but now I'm making less money. Judge, we all know how difficult it is to trace cash. And here we find out that he was actually getting paid checks.
Your Honor, I disagree. We provided checks.
Okay, we provided to who, when?
To opposing counsel. That's how we decided. We squabbled over how much he was going to make, how much to pay child support. That's how we came to a conclusion. I mean, we thought he should pay less, but we agreed to pay more at that time because he was making substantially more money. And we did provide those checks. I remember clearly, providing all the checks we had.
Your Honor, our only information with emails and communication with Mr. Flores is that his client gets paid with cash. The checks that we receive from our client, Ms. Magaña. And today, we had those as exhibits for our initial temporary order hearing, but we had an agreement and we agreed to that number. And now Mr. Aguirre is saying that he gets paid cash now and he's making less money.
And I'm looking at checks that we provided back from his employment earlier this year. I'm looking at a number of them. So to say that we never provided is not true.
I'm talking about temporary order, Mr. Flores. When we asked you initially to give us income verification for temporary order, when we initially got on the case, you said he only got paid cash. It wasn't until after we showed you what we had from Ms. Magaña
Okay, so, but I don't have any checks that have been provided except the one respondent's number 4 that was admitted into evidence. Is that correct?
That is correct, Your Honor. And the purpose of those checks was to establish that the client was being misleading by continuing to say that he only received cash, when in reality, we have proof that he actually received checks.
I think the testimony was he's getting cash now.
Which is,
and has been getting cash, been getting cash since he took a job as a cook.
and Your Honor, I think that that's a little misleading, because there's a company, a big restaurant, providing checks, and now they're only providing cash. And it's really odd that they're now providing cash right before final hearing. And child support is the issue here.
I don't think
That's a
that's what
little
he said.
suspect.
I don't think that was the testimony.
No,
He
I'm not
testified that
saying
it's a couple of months. It's been a couple of months.
Okay. And what agreement is there on insurance?
Well, actually, Mr. Flores didn't want to talk about insurance because he said that the OAG wasn't here. And I told him it's Medicaid. The mother has Medicaid for the child. Law requires that non-custodial parent pay an amount to the OAG for government assistance, but Mr. Flores did not want to talk about health insurance reimbursement for Medicaid. So I told Mr. Flores that if
Attorney
you asked
General, have
about
they
it,
intervened?
no, they
No.
haven't filed anything. But the child is covered by Medicaid.
Okay, and so what number are you asking for, ma'am?
I'm asking for what was agreed, Your Honor, during temporary orders of 598.
And Mr. Flores, you're asking for?
Well, we're asking for in accordance with what he's testified to, which would be 264 a month.
And did he actually testify to what he's making right now?
Yeah, he said 850 an hour, 40 hours a week, no overtime.
Okay, anything else from either side?
Nothing else, Your Honor.
No, Your Honor.
Give me a moment. Okay, I don't want people to become intentionally underemployed, but I also have seen situations where someone takes a job that involves a lot more than a regular work week, whether it's being a restaurant manager or working overseas in pipeline or oil field or something. And I don't think it's good for kids or for society to send the message that if you ever do that, your child support is going to be based on it forever, and you're going to be unable to go back to a more regular work schedule. So I will set child support at $450 a month in order the non-custodial parent to reimburse or to provide the insurance, whether that's for Medicaid or private insurance, if that becomes available. What else do we need to do today?
I think that
And all the other matters we agreed to, Your Honor, the court orders that, just for the
Yes,
record.
and I'll find those in the child's best interest. And you want to have an entry date?
yes, Your Honor. Child support to begin when? Would it be April 1st?
April 1st. Okay, so let me ask Ms. Riley, is she still there?
I'm here, Judge.
Okay, when would be an appropriate date? A couple of weeks out for, is that enough time?
Mr. Flores, you're going to prepare the order?
You changed basically everything last time. Why don't I give you the honor this time?
No, sir, your petitioner, I think you can do that. Thank you.
All right, that's fine.
Okay.
How much time out do you need, sir?
I think at least a couple of weeks, because the last time we had to, make, even though we finished it in a couple of days, we had to make quite a few changes.
April 5th?
April 5th. Let's see.
What date is the court available? I think.
I'm well with Judge Wilson, April 5th, April 12th, 13th, 14th, or 15th would be the next available.
I prefer not April 5th. Where are the other ones?
12, 13, 14, and 15.
I'm available anytime, Mr. Flores. I, with permission of the court's availability, I'm good, whenever.
I can probably do the 12th. Yeah.
I'd like this entered, Your Honor, a little sooner than a month. That's 4 weeks away.
Okay, what was the first date? April 1st?
April 5th, Judge.
I'm available April 1st.
Okay.
April 1st is with Judge Ellison. I mean, unless we put it on your criminal docket, Judge.
They just put it on my criminal docket. We only need it if y'all can come to an agreement.
Sure. I think we should be able to resolve that. I mean, I don't think we're going to have issues.
Okay.
April 1st?
First.
Okay.
We're good, Judge.
Your Honor, I don't think on the arrears, the court made a ruling on that. Did the court make a ruling on that? On how he's
I
going to
didn't
pay?
have any testimony. What's the number?
I thought we
I
agreed.
think $25 a month to catch up.
Yeah, we agreed.
Okay, $25 a month is fine.
Beginning April 1st.
Yes.
Correct.
Very good.
Okay.
Very good.
Okay.
All right, anything else?
Nothing further, Your Honor.
Okay.
Thank you.
Thank you for your time.
May we be excused, Your Honor?
Yes, you're excused. We went over the docket. And Mr. Ramos, I'm going to assume, unless we hear back from y'all, that we do not need the interpreter.
On the 1st.
Yes, sir. Okay.
And I have a question for you, Judge, before we.
What?
I have a question for you. So when I did the
Yeah.
interpretation, I heard just Spanish, so I don't think I did it right on my end. Should I have done?
So yes, you selected Spanish, I believe.
Okay, so I should
The
have
bottom,
done the English. Okay.
and
Maybe
I
that's,
think if you select off, you hear both. I'm not certain.
okay. Yeah, I was like, and I was afraid to mess with it before. I think I've got everything on the docket. If you want to go over it with me, and I mean, that's fine.
Okay, first two cases, reset on request.
Yes.
Jennifer Tapia is the ad litem now.
Yes, and I updated that already, Judge.
I'm sorry?
And I updated that already.
All right, Lorena Bryan, pro se. Did we get an entry date?
On which one, Judge? The Brian?
Brian?
No, we did not.
Okay, well, reset.
Imagine she'll contact me if need be.
I should have had an entry date. I'm gonna put.
Gonna do the April 1?
No, they can set it, but I'm gonna put Tapia to prepare order.
Okay.
Your Honor,
Yes, sir.
you signed the temporary orders?
Yes, and I posted those back to you. The clerk should have received them also.
Okay, thank you, Your Honor. Thank you.
All right, Wishart, judgment to be e-filed. Moss, 4-1, fecal to file objections.
Okay.
Or is it 4-1 entry date?
On the Agita case?
Yes.
Yes, Judge.
Cintas, final judgment, and temporary orders entered. Do we have a follow-up date or not right now?
No, sir. I think they may have sent me. No, they didn't. That's another case I'm thinking of. No, sir.
Excuse me. Okay, so is that it? And the other, the add-on, it was final judgment.
Yes, sir. Okay.
All right. Is that it?
I think that's it, Judge. And I guess we'll see you tomorrow. And Lachey, you have a happy birthday tonight and a nice dinner.
Thank you.
Yes. See y'all soon.
Celebrate one day.
Everybody, one day. Bye.
If we ever see you again.
Right.
Take care.
Except benchmarks the same one earlier. Same person? No, it's different. I do need dates in the same one. Oh, okay. Maybe I should move it to a different spot.
Jennifer, how do I get this thing moved over so it's not like showing on the side over here? Can you? Like my chat, it's all over here on this side. How do I get it where it's not on the side there? Do you have any idea?
That's how mine always is.
I've had it separate before.
When they are doing plea paperwork and they're sharing their screen, it makes it go separate.
Oh,
That's the only time I've seen it when it's separate.
okay. I've seen it. I thought I saw it before, but
And then we have different versions, unfortunately.
okay.
Maybe there might be something at the bottom,
Oh,
like
it's
a
like,
display or something.
I don't
Can you
know.
double click it, or can you grab that and throw it over there?
No.
Yeah.
Yeah, it's just more host only. That's just that.
Yeah. There's nothing in the,
It
what's
won't
the
let you.
more? Is there like a setup
I think that might be
screen?
that.
No.
Oh, well, I just thought maybe
The
some.
only